If you follow surrogacy news, you may have heard about the case involving surrogate McKenna West. And there has now been a major update. Baby Gabriel has been born. I'm going to talk about this case carefully because I think there is a much bigger conversation here for anyone considering becoming a surrogate. Here are the facts we know so far. McKenna West is an Alaskan woman who entered into a surrogate agreement with intended parents based in California. During the pregnancy, at approximately 20 weeks, the baby was diagnosed with a hypoplastic left heart syndrome, also known as HLHS. HLHS is a serious heart defect where the left side of the heart does not develop properly. Treatment typically involves a series of surgeries beginning shortly after birth. And with the treatment, this is a serious condition that can involve lifelong medical complications. According to the court filings, after receiving the diagnosis, the intended parents requested that McKenna terminate the pregnancy. McKenna refused. That's where the situation became extremely complicated. It wasn't simply a disagreement between a surrogate and intended parent anymore. It became a legal battle involving bodily anatomy, a surrogacy contract, parental rights, medical decision-making, and eventually multiple states. McKenna ultimately traveled to Texas, where she sought legal protection and wanted Gabriel to receive treatment after birth. Texas Attorney General Ken Paxton then became involved in the case. A Texas court issued an emergency order requiring that Gabriel receive medically necessary treatment after he was born and preventing him from being removed from Texas while the court considers the case. And now, as of August 12th, Gabriel has been born in Texas. According to McKenna's attorney, the signs following his birth has been positive outside of his known heart condition. Although many details about his current condition and care have not been shared publicly, it's a good thing that he was born alive by the grace of God. Under the court orders, the intended parents are responsible for Gabriel's medical decisions within the requirements imposed by the court. McKenna's attorney says that because of those orders, McKenna has not been permitted to have contact with Gabriel since his birth. She reportedly intends to continue pursuing custody. This is where I want to speak specifically as someone who's experienced surrogacy. I think this case should be a huge conversation within the surrogacy community. Because when you're matching with intended parents, we talk about personalities, we talk about communication, we talk about the compensation, we talk about the birth plans. But you also need to have the uncomfortable conversations. And just here's a few that you can write down, so grab your pen and paper. What happens if the baby receives a serious diagnosis? What are your views on termination? What diagnosis would make the intended parents consider termination? What are the surrogate's personal boundaries? What happens if the doctors give you an uncertain odds? What happens if the surrogate and the intended parents disagree? Those are valid questions that every surrogate should be asking. You should never assume that you and the intended parent are on the same page. You need to talk about it. Because you can absolutely love the intended parents you've matched with and still discover that your beliefs are completely different when you're faced with a situation you never expected. That is why I think matching based on shared values is just as important as matching based on personality. This situation is incredibly sad because there is now a newborn baby needing serious medical care, intended parents fighting for their parental rights, which they wanted to abort the baby in the first place. So I can only imagine what they're dealing with. And a woman who carried this baby for months, and she believed she was fighting to give him the best chance at life. And now look, she has a restraining order out. She can't even, check on and see the baby to see how he's doing. As for whether McKenna was right or wrong, honestly, I don't believe a surrogacy contract should mean that a woman loses the ability to make medical decisions involving her own body while she is pregnant. At the same time, intended parents enter surrogacy expecting to be the parents, and they are also expecting to be the ones making these difficult decisions regarding their child. And that is exactly why these conversations have to happen before an embryo is ever transferred. Contract can spell out what everyone agreed to, but a piece of paper cannot guarantee how someone will feel when they're actually faced with an unimaginable decision. And now I want to know what you think. Do you believe McKenna was right to refuse the abortion? If a surrogate and intended parent disagree about terminating a pregnancy, whose choice is it really? Drop your thoughts in the comments. I would love to hear it. Keep it respectful, and I'll talk to you later.